State, you may proceed.
In the world of Taymor McIntyre, Mark Anthony Saldivar was a nobody. Taymor McIntyre took Mark's life in that Chick-fil-A parking lot. He discarded him there like a piece of trash, and then when he got to El Potosino restaurant, he celebrated his slaying. Ladies and gentlemen, Mark Anthony Saldivar was a somebody. He was a good son, a brother, a friend, a photographer, and tragically, he was the victim of a capital murder committed by the hands of that defendant sitting right there. And we're going to talk about the law that supports that. Now, in your jury form, you have the lesser included offenses of manslaughter and murder. Now, manslaughter is if a defendant recklessly causes the death of an individual. Murder is when the defendant intentionally or knowingly causes the death of an individual, or the defendant intended to cause serious bodily injury and committed an act clearly dangerous to human life that causes the death of an individual. Now let's talk about the mental states. Intentionally is legally defined as the conscious objective or desire of the defendant. Knowingly means that the defendant was aware of the nature of his conduct and the circumstances that existed. Ladies and gentlemen, this is not a manslaughter case. The defendant did not act recklessly. An example of manslaughter would be somebody waving around a firearm and they believe the safety is on and it goes off and kills somebody. That's not what happened here. The elements of capital murder. The state has proved these elements to you beyond a reasonable doubt. You heard multiple witnesses testify that this offense occurred on April 23rd, 2017. It occurred in that Chick-fil-A parking lot in Bexar County, Texas. You heard testimony that the defendant, Taymor McIntyre, was the shooter and that he was committing a robbery when he took Mark Anthony Saldivar's life intentionally, shooting Mark Anthony Saldivar with a firearm. Ladies and gentlemen, the law doesn't require you to be a mind reader. You can infer intent from words and circumstances and facts that surround the offense. So let's look at that. The defendant acted intentionally. He had his firearm displayed from that stoplight at McCullough. He had his firearm displayed the whole time to Chick-fil-A, and he opened his door, leaned half in and half out, and shot Mark Anthony Saldivar. Those are intentional acts. Now, regarding the robbery. Robbery starts at theft. Theft is the unlawful appropriation of another's property, and it is unlawful if you do not have the consent of the owner. What are the facts that prove theft here? You heard Lucy Saldivar testify that she gave her son Mark $10 before he went in that black Kia Forte. The physical evidence that supports the theft is Mark's wallet being at the Mexican restaurant. You see Jalen Bell putting on Mark's backpack at the Mexican restaurant, and Jalen Bell discarded Mark's phone there in the Chick-fil-A on their way out of the Chick-fil-A parking lot. Further, you heard Hester Rogers testify that the back passenger was yelling for help after being forced out of the vehicle. And Joanna Reyes testified that Taymor made the demand for Mark's backpack. Mark refused to give it up, and Taymor had possession of the backpack when Mark was forced out of the vehicle. And Joanna further testified that at the Mexican restaurant, Jalen Bell was mad because there was only $10 in the wallet. Now, how do we get to robbery? It is committing the theft while causing bodily injury to the victim to maintain control or retain control of the property. Ladies and gentlemen, you've heard multiple witnesses testify to that. And the photos from the ME, you saw the knot that Mark had on his forehead. You saw the contusions that he had near his nose and his mouth. That proves robbery. You heard multiple witnesses testify. Ashley Buenteo testified the front passenger used the handgun to strike the back passenger, Paul Caballero testified that the front passenger was fighting the back passenger. Hester Rogers testified that the front passenger was brandishing the firearm while fighting the back passenger. And Joanna Reyes testified that Taymor beat Mark and took possession of Mark's backpack. Now I want to talk to you about the law of parties. Our law provides that a person is criminally responsible as a party to the offense if it's committed by his own conduct or the conduct of another. Jalen Bell and the defendant fled San Antonio with Mark's belongings, and this defendant, even though we have proved that he is the shooter, should you choose to not believe that, he is still criminally responsible for what happened in that car and for the death of Mark Anthony Saldivar, because he was an active participant in the beating and taking of Mark Anthony Saldivar's property. Now, when you retire to the jury room, if you find the defendant guilty of the offense of capital murder, your deliberations stop there. If you do not find him guilty of capital murder, then you would proceed to the lesser included offenses of murder and manslaughter. There are possible defenses to murder and manslaughter, and we'll talk about those. They're in the jury charge. It's self-defense and defense of a third person. Now, just because these affirmative defenses were submitted to you does not mean that the court is indicating anything to you, or that it's just that the defendant is entitled to those affirmative defenses, and that's why they're in the charge. Now, let's talk about self-defense. A person is justified in using force against another when and to the degree the person reasonably believes that the force is immediately necessary to protect himself against the other person's use or attempted use of unlawful force, okay? A reasonable belief is a belief that's held by an ordinary and prudent person. The use of force in this case was not justified for many reasons. One, Mark was not using unlawful force against the defendant. He was merely trying to obtain his belongings back. There's no evidence that Mark ever injured the defendant or even engaged with him in the physical fight. Furthermore, the defendant provoked. If you do find that Mark did use some type of force against the defendant, that force was provoked by the defendant, okay? The defendant is the one who put all of these acts in motion. And the defendant never abandoned his robbery of Mark Anthony Saldivar. And I'll tell you what abandonment would have looked like. Defense is going to get up and argue, oh, the gun was just up in the air, oh, the gun was put away and then taken out again at the Chick-fil-A. No. What abandonment would have looked like in this case is giving Mark his things back and driving off. But that's not what happened. And you see that in the Chick-fil-A video. Now, talking about deadly force, it's pretty much, thank you, Judge. It's pretty much the same as what I just described, except the person that the defendant is acting against has to be using or attempting to use unlawful deadly force. Mark Anthony was not using any deadly force against the defendant. And the defendant does not get the presumption of reasonableness because he provoked Mark, and the defendant was engaged in criminal activity, and that is that robbery. A person is justified in protecting a third party if they believe, or if they would have been justified in using self-defense themselves, which we've already established that the defendant was not entitled to. And the use of deadly force was not justified in this case because Mark was not using deadly force against anyone in the car. They were all using deadly force against him. Now, you all heard many witnesses in this case, and you're the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to the testimony. Now, I want to talk to you about the accomplice witness rule. Now, if you believe that Joanna's testimony naming the defendant as the shooter is true and shows the defendant guilty, you have to further believe that there is other evidence in the case to substantiate what her testimony was. And at that point, you can then find the defendant guilty. So let's talk about the other evidence in the case that tends to connect the defendant with the offense committed. The 911 calls, the lay witness testimony that you've heard. And defense is going to get up here and they're going to tell you, well, there were inconsistencies. Ladies and gentlemen, that's normal. There were multiple witnesses in this case, but they were not consistent about the important parts of this case. Who had the gun and who was in the front passenger. And they're going to argue, thank you, Judge, they're going to argue about the race. Some people said, oh, it was all Hispanics. I urge you to consider where the witnesses were. Elizabeth Adams did say she believed that the occupants of the black Kia Forte were Hispanic. She was standing in the Doubletree parking lot. Everybody that was in the vicinity, Hester Rogers, who was standing right there on the curb, described him as a medium-skinned black male. And the occupants of the car, Ashley Buenteo and her uncle, described a black male as well. The Chick-fil-A video, the El Potosino video, the letter in the clothing and the trunk, the phone records, and the digital evidence all corroborate and tend to connect the defendant to this case and being the shooter in this case. The blue phone that was found in the front passenger glove compartment. Ladies and gentlemen, that digital evidence is telling you who is the owner of that phone. Tay-K47 iPhone and Tay-K47U at iCloud.com. That's the owner of that phone. Now, you have in State's Exhibit 141 phone records from Joanna Reyes's phone. And I want you to take a look at those, because what you will find is if you compare the phone records from Joanna to the call logs in the defendant's phone, which is State's Exhibit 140, you're going to see some overlap, which corroborates Joanna. That first phone number up there was last called in the defendant's phone on March 11th of 2017. The defendant had communication with that phone number 6 times. Beginning on April 23rd, 2017, Joanna's phone calls that number 20 times. The next number, the defendant had communication with that number at least 43 times, and the last call was on March 8th of 2017. Beginning on April 25th of 2017, you'll find that number 8 times in Joanna's phone records. And that last number, the defendant had over 80 interactions and last called on March 8th of 2017, and there's 14 calls from Joanna's phone beginning on April 20th of 2017. All of those things corroborate Joanna. Further, in that blue iPhone, there's a picture of the defendant wearing the slides that were in the car and are pictured in State's Exhibits number 126. Ladies and gentlemen, at this time, your sole duty is to determine guilt or innocence in this case. The state is not required to prove our case beyond all doubt, just beyond reasonable doubt, and we have proven our case to you. You are not to let bias, prejudice, or sympathy play any part in your deliberations, and you have taken an oath to render a true verdict according to the law and the evidence in this case. Ladies and gentlemen, that verdict is finding the defendant guilty of capital murder. Thank you.
Thank you, Your Honor. Just a moment to switch.
May it please the court, opposing counsel, ladies and gentlemen, thank you all for the patience that you've given us and the sacrifice of your time. This is an extremely hard decision. It might be the most grave and serious thing that you consider, deciding the guilt or innocence of someone charged with capital murder. Taymor McIntyre is not guilty. He's not guilty of capital murder. He's not guilty of murder. He's not guilty of manslaughter. And the reason for that is very simple. If you're going to charge someone with that kind of an offense, if you're going to take their liberty away from them, then you have to do it right. You have to do the work. And as this case clearly demonstrates, the work wasn't done. The investigation was faulty, it was incomplete, and by and large, I think it could be summarized as the detective looking at it all and going, good enough. It's not good enough. And you all need to insist on more. If you recall the testimony of Detective Juarez and my cross-examination of him, I think I've given you a clear roadmap about what this case is about and what it isn't about. We all understand that there's a pool of physical evidence and there is testimony conflicting from different innocent bystanders. That information is not enough to convict anyone of a crime. None of the people that were in that car could be convicted on the physical evidence alone that was provided. And everything else that flows from this is the bought and paid for testimony of the accomplice witness, Joanna Reyes. And there is not sufficient corroboration. The law prevents you from convicting Mr. McIntyre solely on the testimony of that accomplice. Let's talk about the physical evidence. We know that there's a 9mm shell casing found outside of the Chick-fil-A. We know that we have a dead body who died from a gunshot wound. We don't have a bullet. At the very basic core fact, the state can't actually demonstrate that that 9mm shell casing and the death are connected. We have gunshot residue on the deceased's hands. We do know that a 9mm handgun was seized off of Jalen Bell in Dallas a few weeks after the shooting. We have a black four-door Kia with a shattered windshield. We have some grainy surveillance footage from the Chick-fil-A and from El Potosino restaurant that doesn't identify anyone, that by itself would not be able to give you any indication of who those people were. We have the discarded cell phone of the deceased. We have fingerprints from Jeremiah Rodriguez. We have fingerprints from Jalen Bell. That blue iPhone that the prosecutor spoke of. A photograph of Mr. McIntyre and Joanna Reyes, and a letter addressed to Mr. McIntyre. So dirty laundry, toothbrushes. We see very significantly a .380 auto bullet, a live round in the front passenger seat, the seat that they insist Mr. McIntyre was sitting in based upon nothing other than the bare word of Joanna Reyes. But nevertheless, a .380 auto round, a bullet that you know could not have been fired from a 9mm. We have a condom in the back seat, a wallet, broken sunglasses, a necklace pendant strewn about in the El Potosino parking lot, a broken SD card. We have these innocent bystanders. And yes, it's normal that people going about their daily lives aren't going to give detailed accounts of that, but don't accept that as some kind of an apology for the state's shoddy investigation. That's not how you should interpret that. Yes, it's normal that innocent bystanders are going to give conflicting accounts, and so that evidence has to be weighed less than it would if someone was able to give a definitive account. You have no eyewitness identification of Mr. McIntyre. You have no eyewitness identification from any of those people of any of the participants in the car. And their accounts differ. We have people saying that all of the members were Hispanic. We have people saying that the man was African American. That doesn't do you a whole lot of good. There are 2 African American people in that car. They conflict about how many shots were fired. How many guns did they see? What exactly was the person doing with the gun? They largely do agree on one important fact, which is that Mark jumped on the hood of that car after he was ejected from it and stomped on the windshield. But let's talk about what you don't have. Each of these things is something that is very important for you to be asking, why don't I have it? And what would it have told me that might have informed my opinion one way or the other? Is that SD card that they found in the parking lot even compatible with a digital camera? Is it compatible with the kind of digital camera they say Mark had? You don't know. We have no idea. What was on the SD card? You don't know. Fingerprints of Taymor McIntyre? You don't have any. None. Any reliable witness who can identify Taymor McIntyre, not even the 2 women going to the massage parlor that day, are able to give a definitive identification of Mr. McIntyre or anybody else that got into that car. An accounting of where the car was in between the time it departed Chick-fil-A and the time it parks at El Potosino. I mean, if we're going to really latch on to this idea that Joanna Reyes says that Taymor was in the front seat and we see somebody getting out of the front seat, aha. Well, okay, we don't know that that's Taymor McIntyre getting out of the front seat, and I don't know what they were doing between. the time period that we're in the Chick-fil-A and we parked at the restaurant. They could have stopped to buy cigarettes. They could have stopped and decided to do a Chinese fire drill for some reason. You have no idea, and they don't either. They're asking you to just jump over that. And you're not supposed to be making those kinds of elisions in your logic. You're not supposed to be making those kinds of jumps. That is not common sense. That is not upholding your duty. That is taking their word for it. And that's not what you're allowed to do in a criminal trial. You never get to take their word for it. Their burden of proof prevents it. His presumption of innocence prevents it. You don't have any GPS data from any of these phones. You don't have any cell tower location data. We have warrants showing who called who. Okay, great. Taymor McIntyre and Joanna Reyes were dating. They called each other. That's not a smoking gun of anything. But that cell tower data could have also told you where they were and when they were there, and you don't have it. We don't have a dump of Mark's cell phone. We don't know anything that's on there. We don't have any idea what their communications actually were. We don't have a dump of Joanna Reyes' cell phone. We have no idea where her communications were. She says somebody broke it up in Dallas. We have to take her word for that. We have no corroboration of what Joanna Reyes did at any point in time after we last see her on that El Casino video, and we only know it's her on the video because she says it's her. We don't have any examples of Mark's work as a photographer. This claim that it's his passion, this claim that that's his thing, this claim that that was his reason for being in that car, they're asking you to take their word for that. There's no proof of it. We don't have a single example of this man being a photographer. We don't have a digital camera, the subject of this supposed robbery, or anything connected with the digital camera. We don't have a backpack. Technical difficulty, Your Honor, I apologize. When it comes to the gun, we have problems there too. You heard testimony that you could do additional GSR work on the hands of Mark Saldivar to try and determine whether or not there might be additional elements besides lead, barium, and antimony that might give you a key as to what kind of ammunition was used or what gun was fired. That analysis wasn't done. You heard testimony from a firearms expert saying that it couldn't have been the gun. But fundamentally, he admitted at the end of the day, it's a subjective science. It's the human eye that's at work here. And he's basing it off of mostly the indentations on that primer. And while he can say that the breech face precludes it from being the same thing, he didn't take the gun apart. So he's speaking about generally what a Smith & Wesson looks like. And he can't speak to the condition of the gun. It's been sitting in evidence for years, 7 years, in 2 different property rooms. And no one came here to talk about whether those rooms are climate controlled, to talk about whether they have an armorer that comes in and cleans the guns. Nothing. And he acknowledged that corrosion can affect how the primer gets indented when it's fired. He had nothing to analyze on those gun magazines, 2 of which are also .380 auto, not associated with that shell casing. And 1 is a 9mm. We don't have fingerprints on those magazines. We don't have anything to tell us whether they're significant or whether they're not. Except we do know that there were a lot of guns in that car. We know that the perimeter of the crime scene didn't include the access road, which seems to me to be a problem when we don't know how many shots were fired, because maybe there are more shell casings. There's no way to say one way or the other. This is really important. We have no search of Jeremiah Rodriguez's home. I'm sorry, but their only witness, the accomplice in this case, says that everybody left that parking lot and went to Jeremiah's house. If we're trying to find proof that someone committed a capital murder by robbing somebody else, don't you think we should search the house that they all ran away to afterwards to see if we might find something? Nothing. You didn't hear from Jeremiah Rodriguez. You didn't hear from Jeremiah Rodriguez's family. You heard nothing about that aspect of the case, which would be the best place to find something that might corroborate anything that Joanna Reyes said. They didn't give it to you. This is a homicide investigation. It's a capital murder investigation. A police officer doesn't get a warrant for a critical scene in the case. There's no search of Joanna Reyes's house, her parents' house. She says that she went to Dallas by the Greyhound bus station. You don't have any footage of her leaving. You don't have any records that she ever bought a ticket. Do we even know that she went to Dallas? There's nothing to prove that Joanna ever spoke to Taymor McIntyre again after the 23rd of April, 2017. They have some call logs that show Joanna tried to call him. But that doesn't seem very consistent with what Joanna tries to claim, which is that Taymor was an aggressive and possessive person. Very significantly, you don't have DNA, and you know that they could have tried to get it. They swabbed Mr. McIntyre's cheek, but they decided that it wasn't necessary. They didn't care what the results were. That's inexcusable. One of the witnesses in this case, Jeremiah Rodriguez, lied to the detective for a full interview about there being a sixth person in the car named John. And we don't have DNA to try and determine who's telling the truth and who's not. We're just going to let his gut steer us in whatever direction it goes. Oh, I think you're lying to me. We don't have DNA on the .380 auto bullet. We don't have DNA or fingerprints on the gun magazines. We don't have fingerprints or DNA on the condom. We don't have any testimony from the lead evidence technician, Kim Wong, who did all of the barcoding from the crime scene at the Chick-fil-A to know whether or not the evidence is all accounted for, correctly labeled, and that it was even available to these laboratory analysts to look at. And you know that mistakes were made because they, for years, had a 9mm shell casing labeled as a 40 cal. You don't have any testimony from Jeremiah. You have nothing from Jalen Bell that was said back then or now. Just a complete mystery. 2 weeks of trial. All of those witnesses. This stack of physical evidence here in front of you. What do you have? Taymor McIntyre was in the car at some point. Was he there on that day? Maybe. Maybe not. When was he last there? They can't tell you. Did he have a gun? They can't tell you. Did he shoot a gun? They can't tell you. Did Mark start this fight? They can't tell you. Was there a fight? They can't tell you. They can't tell you a single thing about what happened inside of that car at all from any of the evidence that's piled in here. Now, their theory, as you know, rises and falls entirely on the testimony of Joanna Reyes. Proving that Taymor McIntyre was in that car is not enough to convict him of anything. Mere presence at the scene of a crime is not enough. The jury instructions tell you that explicitly. As a party, as the primary actor, doesn't matter. Mere presence is not proof beyond a reasonable doubt. That's the law. Joanna Reyes is lying. You know she's lying for several reasons. First, Detective Juarez knows she's lying. Everyone knows she's lying. The state bought and paid for that testimony at an extremely high price. Joanna Reyes was an adult when this crime occurred. She is facing life in prison without the possibility of parole or the death penalty for a capital murder. And rather than facing those consequences, the state offered her a plea to tampering with evidence with deferred adjudication, meaning that she'll never have a felony conviction for this offense. She'll be eligible to have it non-disclosed, meaning that when she goes out there to apply for a job or get an apartment or do anything, this can be ignored. Won't be on the radar screen of people out there in the free world. And even though it's a 10-year term, the terms of the agreement allow for them to knock off time as things progress, so long as she's truthful. But we all know what that means. There's only one arbiter of whether she's truthful, right? They're not looking at your verdict to decide whether she's truthful. Don't worry, you're not deciding whether Joanna Reyes gets a better outcome or not. The only thing that decides whether she's truthful is what they think. The ones who are calling her to testify. That's not an acceptable way to run a justice system. Compensating people with their freedom to obtain the critical information they need when none of the physical evidence supports it is not a way to run a justice system. Her inconsistencies in her testimony are too many to recall. I don't know if I'm going to be able to list all of them. I know for certain that while Joanna maintained for a long time that this was all Taymor's idea, and that Taymor was the one talking to Mark on the messaging system, and this was what Taymor wanted, and it wasn't me, you heard her on the stand acknowledge that after lying and minimizing that forever and ever and ever, she finally has decided that she can say, all right, well, he contacted me first on Instagram, and he solicited me for nude photographs, and I blocked him. And then I later changed my account, and we got in contact again. And then we talked about this photo shoot, and he wanted it to be in lingerie. This is all about her career as a stripper. There is no evidence that this is actually anything that Mr. McIntyre wanted. There's no evidence that Mr. McIntyre was even aware that she was communicating with him. You have no way of knowing that other than her claim. A claim that she has every incentive in the world to say, irrespective of whether it's true. The idea that the photo shoot was rescheduled as to called off, I think, is an interesting thing. You heard testimony. Mark didn't have any other appointments. And the testimony was that he was basically saying, we're not going to do the photo shoot, but give me a ride to North Star Mall, which is where we said we'd do the photo shoot to begin with. That doesn't make sense. That doesn't make sense. She's hiding something there. I don't know what it is. I can't tell you what it is. But it's not my job to. They have the burden of proof here. And at its core, nothing corroborates her claims. If you want to tell a policeman that despite what it looks like, you are not the getaway driver or the perpetrator or involved in an armed robbery and a death that occurred in the Chick-fil-A parking lot, that it really was all a big misunderstanding, which is what she tried to do desperately for a very long time, you would show the detective your communications with the deceased to clear all of that up. And you would explain
2 minutes.
how that all develops on. We don't have any of that. She didn't give you that corroboration. And that malarkey about someone broke my phone, they have nothing to back that up either. We also know she's full of it because, come on, I thought he was 18. Look at the photographs. No one would mistake that child for an 18-year-old man. He's a 16-year-old boy, and she knew it. She was afraid. She had court the next day. There are bailiffs in every courtroom in America, policemen, everywhere. If she was afraid that she was going to have something happen to her because of what she saw, ample opportunity existed. She spoke to the detective, in this case, on the telephone. She gave her fingerprints and her ID when she went to go dance up in Dallas. She had her father take her to the bus station, passing up opportunity after opportunity after opportunity. You have to first believe the accomplice before you even go into this question. You don't get there. I don't think anybody can get there. And then, even if you do believe her, you still have to have independent corroboration that connects Taymor not to the scene of the crime, not to the car, but to the commission of the offense. You have nothing. Not a shred of evidence supports that. Zero. Nothing corroborates her story. The justice system in America depends upon the state having to meet an exceedingly high burden. It should be extremely hard to put someone away for capital murder or manslaughter. They haven't given you that. Demand more. Expect more. It is okay to have your doubts, and it is okay to rely on those doubts. It is your duty to expect them to work to dispel them, and they haven't. And lastly, I just want to say, we're counting on you. Taymor needs your help. If y'all don't hold them to their burden, we're going to have a miscarriage of justice today. No one wants that. I count on you to do your duty. I know that you will return a verdict of not guilty as to all of the theories the state has put forward. Thank you. Mr. Goldstein.
Ladies and gentlemen of the jury, able counsel, Taymor. This is a capital murder case. It's an important case, obviously, to take. But I think we all take it seriously. I've been watching them. I can tell you that I'm impressed. I'm going to try and just summarize quickly. Judge Boyd is the judge of the law. She decides the law. You've been watching her rule. I told you we were going to have some disagreements. Objection, instruction, don't disregard. I don't know how y'all keep track of it. We're having trouble keeping track of it. But y'all been paying attention, and I think you've been following those instructions. But y'all, each and every one of y'all, are the judge of the facts, the sole judge of the facts. Each and every one of you, in your own mind, you make these decisions. No one will ever be able to come back and look into your mind and ask you about that. That's important. This is Taymor's case. I told you I was going to summarize, so let me just tell you that there were a lot of inconsistencies. I told you a lot of this was going to be kind of boring. It's like watching paint dry. I mean, you sit there and watch over and over again. And I said, that's because that's their job. They've got to do it. They're able counsel. I respect them. They're trying. And they've got to put that before them. But there are some things in dispute. One of the things I talked to you about was inconsistency. There were a lot of inconsistencies here. For example, one of the witnesses, I think her name was Ashley Bontello, she said there was a female driver. Another said they saw only females in the car, and that was Eliza Adams. Another said there were two males in the front seat. That was Anna Delgado. Some said there was one shot. Some said there were two shots. There were others that said there were three shots. Joanna Reyes, who we're going to be talking about her at the end. You heard able co-counsel John Hunter talk about Miss Reyes. She said she couldn't remember. She was in the car. She couldn't remember how many shots. We're going to talk about, you've already heard some things about the police investigation. I kind of like Sergeant Detective Raul Juarez. He's an able and he's professional. But let me just tell you, despite all the swabs they took, you saw the officers swabbing each parts of the car, all the evidence. It's interesting. They never took they took our client's DNA, they never compared any of that. There was no effort to do that. Why? The 9mm weapon, the one seized from Jalen Bell, it was never even compared to the spent cartridge. It sat there for 7 years in Fort Worth. Then it was brought to San Antonio. And that wasn't done until we asked for it. 7 years later, they had never done that. I don't think guilty people would be asking for that sort of thing. The spent round, the one spent round found, where was the lead crime scene investigator, the CSI? Remember the woman? The only way I remember is that they had a lot of pictures of her high heels. There's nothing wrong with high heels. My wife of 55 years wears them all the time. But where was she? She's the one that picked up all that evidence. She's the one that bagged it all. Remember? Where is she? That nice homeless woman, she managed to get here. They have the burden of producing evidence. Where is the officer that made that you saw the report? It's in the evidence. The report where he says it's a, what did he say it was? A 40 caliber, the 9mm cartridge? That was a mistake. Is that a giant mistake? Is that a reasonable doubt? I don't know if that's a reasonable doubt. But we're talking about cumulative. This is not our best efforts. There were no fingerprints obtained from the vehicle of Taymor. Didn't they compare any prints? There weren't any done. There were no fingerprints of the magazine. Remember, there were 3 magazines found, only one of them a 9mm that he just showed you. It fit perfectly in the weapon seized from Jalen when he was arrested 5 days later. There was no search of any residence. Why is that? I mean, you see it all the time whatever you watch on TV, when they're trying to find people, they always go to their residence. They seize their residence, look through their electronic media. There was no search of Joanna Reyes' residence. There was no search of Jalen Bell's residence. There was no search of Mark Saldivar's residence. There was no search of Jeremiah's residence. Remember Jeremiah Rodriguez? That's where they went right after this happened. Why wouldn't you want to search there? Why not? Well, our able detective said there wasn't any need to. He had made up he doesn't get to make. The law is very clear in this state. No witness, no matter how much we like them and no matter how professional they are, no witness gets to make your decisions for you. No witness gets to tell you who's guilty and who's not. Not in this country. Y'all get to decide. He decided that early on. That's why he didn't do it. He told you. I didn't think I needed to. Jalen, let's get to the facts of this here. Do all those things amount to a reasonable doubt? Do any one of them amount to a reasonable doubt? Do they cumulatively, all of them together, amount to a reasonable doubt? I don't know. That's your decision, not mine. But it's certainly in the best performance by our San Antonio police force. Jalen Bell, he had, there was only one 9mm retrieved in this case, and it was seized from him. And remember the testimony by Joanna Reyes? Yeah, he had a gun that day. He always had a 9mm. This guy, he always was packing. And it was a 9mm that he packed. Think about that. There was one spent cartridge found that they didn't even compare until we asked for it 7 years later. And one weapon, 9mm, one cartridge, 9mm. Was it Jalen Bell seemed to always have a 9mm with him. That was how he ran. Jalen Bell's are the only fingerprints they took, and they were on Mark Saldivar's telephone. Jalen Bell. Remember, that guy's a big boy. 6'4", 240 pounds. Taymor, little slight. 15 when Joanna Reyes met him. 16 when this happened. Jalen Bell's the one that rummaged through the backpack. He's the one that the testimony is rummaged through the wallet. What about him? Why not search his house? Where is he? We don't have any obligation to you heard the charge. I know it's long, but take a look at it. It tells you that we don't have any obligation to bring in any evidence, not to call any witnesses. It's the prosecution's burden, a heavy burden. They have to prove beyond a reasonable doubt every element of the offense. Why didn't they bring Jalen Bell?
Time.
I thought I was going to get a warning.
I did. Thank you. All right, State, are you prepared to proceed? You have remaining 16 minutes and 47 seconds.
May I have... I prepared this last night. Can I just have a few minutes more?
No, both sides agreed to 30 minutes. That's what both sides are receiving.
I'm going to beg the court. Can I have 2 minutes?
No. All right, State, are you ready to proceed?
Yes, Your Honor. Just for a second, Judge, just gotta set up the text.
ladies and gentlemen, I'll be the last one speaking to you. I know it's been a long 2 weeks, so I'm going to try to be as brief as possible. As you notice, the judge is going to hold me to a 16-minute time interval. So after I speak with you, you're going to have the opportunity to go to the back. The charge that the judge read to you, you're going to get that, a copy of that, and you're going to be able to review that back there, okay? So what I'm going to do is jump right in about the capital murder here. The state has proven every single element of capital murder. If you look at this on April 23rd, most of these are not in contention here. April 23rd, 2017, Bexar County, Texas. The death of Mark Anthony Salvador was by a deadly weapon, by a firearm, by a shooting. And the only things in contention that defense is arguing is Taymor McIntyre was not the one that did this while he was attempting to rob. I think the evidence overwhelmingly, if not beyond a reasonable doubt, beyond almost all doubt, that we have the correct individual. I'm going to talk about Joanne Reyes briefly right now and then go over evidence with you that came on in this case. Right here, I'm going to read it to you. Joanna Reyes, accomplice. She is an accomplice to this. She did plead to tampering with evidence of that car. She fessed up, took responsibility for her part. She did not shoot Mark Salvador. That man right there did. That's what we're trying to do, is make somebody that killed someone take responsibility. Joanna took responsibility. You look at all the evidence. Joanna did one thing. She was driving that car. You saw when she got out of that car. She's freaking out. You heard testimony from Jasmine Cruz saying she looked freaked out. If you watch that video, what are those two other individuals doing? Jalen Bell, 6'4", 200-something pounds, and the slight individual, Mr. Taymor McIntyre, walking around like it's another day. A day in the life of Taymor McIntyre. A day in the life. That's what Joanna gave you with her testimony. That's what she gave you. A taste of the life of Taymor McIntyre. A person that shot down another individual for the sole purpose of taking a camera and a backpack and $10. That's a day in the life in Taymor McIntyre. Just one day. She was an accomplice, but she took her responsibility. Defense counsel's correct. She's getting deferred. She's been on bond for over 7.5 years. As abided by that. Has not broken the law. Has not broken bond. She came in here and testified. And you know what people do, or what they're labeled as when they testify? Snitches.
Your Honor, may we approach?
All right, stage, you may continue.
Thank you, Judge. Ladies and gentlemen, I'll go into Joanna Reyes. She is an accomplice, but she took her responsibility, has taken her responsibility. Her testimony needs to be corroborated by other evidence tending to connect the defendant with the offense. Tending. Not beyond a reasonable doubt, just connecting him. Tending to connect him. Okay? Keep that in mind. But then, after you find that evidence, that corroborating evidence, you add that with all the other evidence that came into this case, including her testimony, including what she said, and everybody else said, all the evidence, and then you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. The corroborated evidence that corroborated her, and then also all the evidence, including her testimony, equals a guilty in this case. Let's go over that. This is the video. I want you to watch this video if you need to over and over, unless you've seen it enough already. The fact is, if you watch that video, one, Mark Salvador stomping on that windshield. No doubt that he stomped on the windshield at some point. But you watch that car and it lurches forward, what does he do? He falls down on his hands and knees. He slides off that vehicle as it goes back. Then you see the white shirt pop out. Boom. If you listen to the ME's testimony, that individual was shot in the shoulder. Mark was shot in the shoulder. It was from left to right, downward, from front to back. He wasn't standing up stomping on a windshield. He was on his hands and knees, being shot by Taymor McIntyre to his left. It went across his body and exited out his lower part of his back. Look at the evidence. He was not stomping on a windshield when he was shot. You see it from that video. Chick-fil-A video. The corroborating evidence in this particular set is the fingerprints of his accomplice, Jalen Bell, that has been testified to thoroughly. Jalen Bell is best friends with Taymor McIntyre. They still had contact after this. They still had contact, much contact, up until months ago. In fact, if you listen to State Exhibit number 118, you hear Taymor McIntyre say, I gave pimps money. Gave him money, so why did he give him money? But Joanna Reyes is getting bought off. Remember that. Fingerprints of the accomplice Jalen Bell, best friends. The jail calls tell them about that best friendship, and also money being transferred to Jalen Bell from Taymor McIntyre. They arrived together in town in San Antonio, and then they left together and escaped off, one to Dallas. Jalen Bell gets caught there, but if you listen to the testimony of the officer there was another individual with him. Who was that individual? Where did that individual go after his buddy got caught? He ran off to New Jersey. Connection to what? That letter that was found in the car. That's also corroborating evidence that he was there at the crime scene and committing this crime. Altogether, also testimony in here, you got that shell casing that was tested against the gun. It did not come back to that gun. You heard about the one shot. Several witnesses testified to that. You got shows that the front seat passenger in the white shirt, watch the video, it's a white shirt. Watch the El Paltacino video, it's a white shirt. El Paltacino video as they pull up, or when they have pulled up already. That's Taymor McIntyre walking around a car. That is Taymor McIntyre in that white shirt that got out of that front seat passenger, and that's the individual that shot Mark Salvador. If you look at the timestamps on these videos, also at the beginning of each of the videos, you'll notice that the times 5:19 was in the Chick-fil-A parking lot. When the initial video of El Paltacino, it's registering at 5:20. Maybe a minute from one location to the other, if not seconds. So that Chinese fire drill that defense counsel was mentioning, probably a pretty fast one, I guess. El Patrocino, the black Kia is there. This shows the 4 individuals in that vehicle. You have been told who those are. The white shirt of Taymor. You watch that video image, and that's Taymor's physical body. He is a 16 and a half, almost 17-year-old individual, slight build. He's growing up. He's growing into Taymor McIntyre. The wallet is found of Mark's, establishes robbery at this location. You watch that video, you watch Jalen Bell, 6'4" of him, 240 pounds of him, putting on a backpack. You see it as he goes out and he's walking with Taymor McIntyre. You see him take the backpack off and then rearrange, and they walk off into the night, or the day rather. More corroborating evidence, a lot of corroborating evidence in that black Kia. How many of you, everybody in this room, where's your cell phone right now? You know exactly where your cell phone is. Taymor's was in the glove compartment of the black Kia that was in the murder investigation. That's where his cell phone was. You know where your cell phone, everybody knows where your cell phone is. Taymor McIntyre left it in a car because he was running off into the day to get away from that vehicle from a murder. You also heard my co-counsel, Ms. Galloway, talk about the phone records. That's in evidence. Taymor's phone records compared to Joanna's phone records. There's intermediate phone numbers mismatched several times. Jeremiah's fingerprints are found in that car. Sergeant Wars established Jeremiah was in that car through his investigation. He was interviewed by Sergeant Juarez. His rendition, his interview is consistent with all the other evidence that was collected. Clothes of Taymor, Jalen, and Joanna were found in that car. The slides, the jerseys all match up with Taymor McIntyre being in that vehicle. Letter belonging to Taymor McIntyre is in that vehicle. Also, the photo in the center console of Taymor and Joanna. If you look at this, that photo on the left-hand side is that photograph that's laying in the console in the middle. Shows her in a jersey of that Chicago or some type of football jersey with Taymor, what you can see is white high tops, Nike. The wallet to your right is Mark Salvador's, testified by Miss Salvador, his mother. That's evidence of a robbery. That's not the scene of where it happened, but it happened at Chick-fil-A or at that intersection. It was ongoing the whole time. If somebody's robbing you, they're taking it, and you're trying to stop them from taking some of your objects, you can try to stop him. He tried. Corroborating evidence, all 4 of these witnesses testified a young black male in that front seat with a gun. Ernest Reyes testifies that Mark screams, "Help, help, give me my things, give me my things." Evidence of a robbery. Witnesses, Anna Delgado, Gabriel Baez, Jasmine Cruz, which we've already spoken about, describes that scene when she was there. Lucy Salvador, the mother of Mark, establishes Mark was excited about a photo shoot.
5 minutes.
911 callers, you've heard from all of them. Little inconsistencies, I agree. Defense counsel is very able to determine, some Hispanic, a white person or something like that. But, the fact is, if you look at the consistent things, front seat shooter, a gun, a black car, and guy on the hood. Consistent with everybody else's testimony. That's one word you're going to hear over and over is consistent, consistent, consistent. Taymor runs off to New Jersey. He's found up there, and then he's brought back to Tarrant County. Then he's brought back to Bexar County to face these charges. Intending to connect the defendant with the offense, everything that I just went over, but reiterated. Fingerprints of the accomplice, Jalen Bell. Jail calls established McIntyre and Bell's friendship. Video image of El Patrocino matches Taymor's physical body. The blue iPhone belonging to Taymor McIntyre. That phone. Taymor's phone records are Joanna's phone records. Testimony of Mark's phone number on Joanna's phone records. Jeremiah interview consistent with all this evidence. Clothes of Taymor and Jalen and Joanna in that car. Photo in the center console of Joanna and Taymor. And then the letter belonging to Taymor. This is all corroborating evidence that you can use in your determination of an accomplice, witness, testimony, and the truthful of that. Because the fact is, there's that letter. addressed to Taymor, the same place where his phone is found in that vehicle. Remember, property damage just needs to tend to connect and the defendant to this offense. 10. Doesn't have to be beyond a reasonable doubt. But then you add all this evidence together, all of it together, and you get a view of incredible evidence together, and you get consistent evidence confirmed by overlapping evidence, video, testimony, and all other collected evidence equals beyond a reasonable doubt of guilty. Easily. Briefly, if capital murder, that's what we're asking for, the guilty. And just to briefly, since it was brought up, if this is self-defense, what are we looking at then? What type of society? If robbing a victim and then say,
I object, that's improper argument.
I'm asking you to enforce the law here, because if you're robbing somebody and you take something from somebody and then you argue that the defendant or the victim doesn't have a right to get it back, not here. The defendant provoked the victim by taking his things, his passion.
2 minutes.
Mark Anthony Salvador died that day. Justice for Anthony Salvador. He had a passion of photography. His mother testified to that. That's evidence. He had that camera that you see in this photo that was never found, might add. I agree with counsel. Never found. Why? Because of that man and his buddy. Make him take responsibility. You go to the page in this charge and go to capital murder, and then you flip to the back to the verdict form and say guilty of capital murder, because we have proven every single element beyond a reasonable doubt, especially that this individual, Mark Anthony Salvador, deserves justice. After so long, so many years later, he deserves justice. And just because it's old doesn't mean that it's bad evidence, but he deserves it. His family deserves it. Heck, we all deserve that. We don't want a society like this.
Objection, improper argument.
We want law enforcement, and that's what I'm asking for. Hold Taymor McIntyre, Tay-K 47, accountable, and come back with a verdict of guilty on capital murder. Thank you, ladies and gentlemen.